financial arrangements are one of the most important questions that people ask me when their marriage has come to an end, or their civil partnership has come to an end, because obviously they're concerned about money. They're concerned about what's going to happen in the interim, what's going to happen in the longer term, what's going to happen in the future, what are their rights. And they do have rights, and those rights are set out in law. Those rights are set out in the Matrimonial Causes Act 1973. And so the financial claims that they have against the other party, relate to pension, relate to property, relate to capital, so, anything else really, other stocks and shares and savings, etc. And the starting point for division of assets that have been accumulated during the marriage is generally 50-50. Maintenance is separate, that's dealt with under income claims, and whether there will be maintenance paid to a spouse will be determinative on need, and whether there is a need for that to be paid. That's not just an automatic a sharing, as a capital awards are. But then we look at, well, how do we arrive at, is it just a straightforward 50-50 case? And a lot of people obviously want to know that. And although that's a starting point, the court, or we as lawyers, will look at certain factors within the Matrimonial Causes Act under Section 25. And the most important factor will be the housing needs of any children. So if there are children involved, for example, it may be that a 50-50 split isn't a fair and justifiable outcome. And it may be that, therefore, there needs to be a departure from equality and the assets need to be shared unevenly. It will just really depend on the circumstances of the case, and indeed what the assets are, and whether the needs of the parties can be met from the assets without penetrating the other party's share, or looking at assets that have been brought to the marriage, pre-marital assets, or assets post-separation that would be treated differently by the court. So I think, what we always look at is, well, what's the position now? Because parties may be, looking to move out of the family home, for example, so they might need financial support with that, or they may need to live together for an interim period, pending an overall settlement when perhaps one moves out or the house is sold or something like that. So it's very much going to be dependent on the circumstance of the individual client, and what's going to be best for them. The other thing to say is that the financial claims don't just happen, they have to be activated. And those financial claims are activated within the divorce application, what used to be called divorce petition. And the divorce petition or the application to dissolve a civil partnership. And so the financial claims are set out within that document, and that opens those financial claims up. And once they've been opened up, they need to be closed down by way of an order of the court. And that order can be by way of consent, by an agreement that the judge is then invited on paper to approve and seal, or through a court process and ultimately a judge's decision.